Okay, greetings everybody, and welcome to Customs and Border Protection's Protest Webinar. My name is John Leonard. I'm Executive Director for Trade Policy and Programs within CBP's Office of Trade. As of December 1, 2020, there are 106,505 open protests, that meaning in open or suspended status in our protest module. So again, well over 100,000 protests currently with CBP in an open status. Our trade partners in the Commercial Customs Operation Advisory Committee, the COAC, have asked that we do the seminar, and we really very much in agreement with them on that. And so hopefully you're going to find today's webinar useful for you. This is a collaborative effort between a few different offices within CBP, including policy, legal, and operational, have come together to address all the various issues within protests, including those specific protest questions that were submitted by our COAC. The overarching intent is to provide you with information to help you better understand the protest process, and thereby will help you to understand how CBP works in processing your protests. As you all likely know now, the volume of protest submissions has truly exploded in recent years, in large part due to the trade remedy exclusion process. To give you some context, in the years directly prior to 2019, CBP received an average of 28,000 protests per year. Starting in 2019, that number doubled to nearly 60,000. And now in 2020, the number of protests has skyrocketed to a total of 193,000. As I mentioned, over 100,000 of those are still in open status. So that's a 221% increase in just 1 year. As far as housekeeping for today's webinar, it will be recorded and posted to cbp.gov. All participants are muted, but we do want to address questions on topics that we don't cover in the presentation. As such, please submit your questions in the webinar tool, and we will address as many as we can at the end of the presentation. We encourage you to hold submission of your questions until we finish the Q&A session at approximately 3:15, in as much as we hope to address as many questions as possible with the content that we'll be delivering. The high-level topics that we'll be covering in today's webinar include trade remedy protests, key aspects of filing protests, applications for further review, best practices in protest filings, and finally, accelerated disposition and Court of International Trade filings. So right now, I'd like to introduce our first speaker, Mr. Alexander Amder, Director of Anti-Dumping and Countervailing Duties and Trade Remedies Division within the Office of Trade. Alex.
Thank you, XT. I'm going to provide just a brief overview of trade remedies. We've been working very closely with CBP's Commercial Operations Advisory Committee on issues related to trade remedies, and that's where basically this recommendation for this webinar originated. When I'm talking about trade remedies, I'm specifically talking about Section 201, Section 232, and Section 301 trade remedies. And one of the unique features of both Section 232 and Section 301 is that they have retroactive exclusions. And basically what's been happening is by the time that USTR and Commerce Department have approved exclusions for the respective remedies, many of the underlying entries have liquidated. And a result to gain advantage of the remedies and of these exclusions, the importers have been protesting the liquidations and to gain benefits of the exclusions and the refund that they're entitled to. We've also been seeing other protests related to trade remedies, but that's really, as far as I know, where the bulk of them are coming from. I really wanted to emphasize is that you can completely avoid the protest process related to many of these trade remedy exclusions by by requesting CBP to extend liquidation of the entries. If an importer has or another party has an exclusion pending with the Commerce Department, or if an importer knows that their HTS has an exclusion pending with USTR for Section 301, you can request CBP to extend liquidation of the underlying entries. And so when you request liquidation, of course, the entries and CBP extends liquidation, the entries will not liquidate. And then when if you're awarded the exclusion, then you can just file a post-summary correction and completely avoid the protest process altogether. We provided guidance on this in CSMS 425-66154. That's listed later in this presentation, and we really recommend that you consider taking advantage of this. Again, so that's my brief overview of the trade remedies and protests. I'll hand it back to you, XD Leonard.
Thanks so much, Alex, for that great information on the trade remedy protest process. Right now, to address key aspects of filing protests, I'd like to turn it over to Matt Ernst. Matt.
All right. Thank you, Executive Director Leonard. Next slide, please. Throughout this protest webinar, we'll be covering some key elements of submitting a protest to CBP and what is required within that. We can start off with some governing statutes and regulations as to protests. First and foremost, the main one is 19 U.S.C. 1514, which is the main statutes for kind of the who, what, when, where, and how of protests. And then we have 19 Code of Federal Regulations, Part 174, which adds additional detail and information for the regulations for protests. 19 U.S.C. 1515 delves into the review of protests and certain aspects of reviews of denials of void denials and denials of AFR, application for further review. Then we have 19 U.S.C. 1520D, which covers the refunds and errors for goods of qualifying under free trade agreement rules of origin. And finally, we have 19 CFR Part 141-105, which doesn't necessarily cover protests in general, but as a protest cannot be submitted that is adverse to the importer. So a protest submitted cannot create a bill for an importer. That would be the incorrect method to correct errors on an entry after liquidation if duties are owed. You would need to voluntarily deposit those additional duties within 90 days after liquidation. Beyond that, a prior disclosure would need to be submitted. Next slide, please. So we'll get into submitting a protest to CBP. The ACE protest module is currently the only electronic source that a protest can be submitted to CBP, but paper protest in a Customs Form 19 protest form or any other paper form, a protest is able to be submitted to CBP. As I said before, all protests submitted to CBP electronically must be submitted through the automated commercial environment. And that's electronic-wise, protests submitted through email or fax are not allowed. You do need a protest filer account in ACE to submit a protest, and we have a link in the slide here for the instructions where you can request that account. And also, you do not need a primary ACE account to then request a protest filer account. You can request either or both. Next slide, please. All right. Now, creating a protest in ACE, the ACE protest module supports 514 protests that are covered under 19 U.S.C. 1514 or 520D protests, which are post-importation preference claims under 19 U.S.C. 1520. A good rule of thumb to start out your protest is to input the lead entry number for that protest in the corresponding field in ACE. This will autofill a number of other fields, importer of record number or the port code, and the team number for the review team with the Center of Excellence and Expertise that will be reviewing the protest. This is a good first step. It kind of sets the main information of the protest without having to kind of look up all that information. Now, protests can have more than one entry on them. And to add additional entries, there is a manual way through the ACE protest module to add additional entry numbers. Or you can upload a file with those entry numbers. It must be a TXT file, and it can be no larger than 1 megabyte, I believe. ACE will perform validation checks on this information, mainly to verify that the entry numbers that you are associating with your protest are actually in ACE, and also things like importer record number or a broker number or any other type of information along those lines. ACE will confirm that it does exist in ACE and is a valid number. At this time, I'm going to hand it over to Branch Chief Sherry McCann to cover some additional topics. Sherry?
Thanks, Matt. Good afternoon, everybody. We do want to go over some specifics within the protest party definitions because, as XP Leonard mentioned, we received specific input from the COAC on topics to cover, and this, in fact, was one of those topics. So we really do want to go through these details and make sure everybody understands which party is what. And this is information that is submitted with your creation of a protest. So to start, the protestant type and protestant number are identifiers for the party for whom the protest is being submitted. The protestant type is the party type or trade sector for whom the protest is submitted, that is the importer, the filer, the surety, the attorney, and then the protestant number is their actual identifier, the IOR number, the filer code, the surety code, etc. And with the combination of those two data elements, ACE will validate that the party actually exists in ACE, which is a system of record, of course, for all of our account data. Then we'll go on to the protest filer type and protest filer number. This, alternatively, is the information for the party who is actually filing the protest. So ACE will require selection of a protest filer type, and as a trade user, ACE will identify you when you log into the system, and as such, will populate your protest filer number with the number that you used for your login to create that connectivity. The next party definition is the substitute party type and substitute party number. These are optional fields, and this information is to identify an additional party to whom notice of approval or denial of the protest should be sent. And then finally, we have the refund care of number, and this is optional as well. This is used if the refund needs to be sent to a separate party. So this is information, you would only enter this information if you have a CBP Form 4811 on file, a special address notification. And the refund care of number must be an importer of record number. Can we advance to the next slide, please? So we also want to talk about the reason for the protest, as this is important information for us as well. So the reason for the protest is box 8 of the CF-19, and this is where the protest filer explains in detail the issue being protested, and what the filer is providing to substantiate that protest. So the field also exists in the electronic version, of course, in ACE, and it is a required field. And if we just look at what we need in this field, because it is critical, we need to see, CBP needs to see a very clearly and concisely written reason for the protest that thoroughly explains the argument and the substantiation of the protest and the nature and the justification for the protest. This is critical for our CBP Centers of Excellence and Expertise when they're reviewing these protests to be able to conduct a timely and accurate review. And we're going to hear more about best practices on this a bit later, but this is a key element in the protest submission. So if the trade user submits a blank reason for a protest, or it's overly minimalistic, that will greatly increase the processing time for protest, as the center will need to take additional time to review, to reach out to the filer for a more thorough explanation to understand what is actually being protested. Within this reason for protest field, there is a space limitation. So the users can input, trade users, when you're filing protest, can input the additional documents. And that will enable the reason for the protest to be expanded in a document or documents uploaded under the Upload Additional Documents section. Okay, so again, that's additional documentations to expand on the reason to give more space, and that would be uploaded in the Upload Additional Documents section. So with respect to file types, all file types are accepted except for the ones listed, TIF, TIFF, and TXT. And there is a size limitation. These can be no larger than 10 megabytes. So that covers reason and definitions. And with that, I'd like to turn it over to my colleague, Mr. Ernst.
Thank you, Sherry. Next slide, please. And as Sherry mentioned towards the end of that topic about uploading documents is, or providing them additionally with paper protests, is a big part of providing your substantiation for your claim at protests. In addition to the reason for protest being able to be a document and uploaded in the ACE protest module, additional documents will most likely need to be uploaded to substantiate your claim. And I think this is one of the biggest areas for maybe confusion about what needs to be uploaded. There is no overall set parameters of what needs to be uploaded. It goes very specifically to the issue you are protesting. I mean, the number or the type of documents you provide to CBP for your protest have a great range of, the commercial invoice, packing slips, measurement sketches, maybe mill certificates. What CBP is mostly looking for is documents that tie back to your protest claim and can prove your claim to CBP so that you can get your protest approved. In addition to using that for, any type of, protest, the trade remedy protests as well, especially specific to exclusion protests, providing the kind of section 232, section 301, the tariff numbers and product descriptions that are involved, because those exclusions are very specific to usually, a small set of products that have that exclusion. So that needs to be provided. And basically any documentation that ties back to your claim that helps substantiate your claim to CBP is what CBP is looking for documents. Next slide, please. And status notification. once you, the protest filer, if you have a protest filer account in ACE, that should automatically populate some fields when you are submitting a protest, and one of those would be the email address that notifies you of certain status updates of your protest. And additionally, the final notification of the decision. As Sherry mentioned, the substitute party type is also available to send additional notifications. And I believe there is more than one email field for your account so that notifications can be sent to multiple people. We also want to kind of key on not only for protest filing, but all kind of contact information within ACE. We would ask that it's reviewed and updated often enough. This is sometimes our only contact information that CBP has to reach out to members of the trade for whether for protests for additional information or for clarification on certain issues. So having this information up to date greatly increases the communication between CBP and the trade, and can cut down on time between communication back and forth and the ultimate processing time of the protest. Protests submitted in paper form still have to have the protest decision mailed through U.S. mail back out to the protest filer. Between submission of a protest and the protest decision for paper protest, there is no update. No updates are sent. Next slide, please. Another issue that comes up often enough is the amending of a protest. Protests have the same amendment time frame as protests that can be, as the time frame that protest can be submitted to CBP, which is no later than 180 days after liquidation. So, and protests can, be for any number of reasons. If you are adding an entry or taking away an entry from a protest, or if you are, adding an additional claim to your protest. If you're protesting classification and then maybe a value issue arises, as long as CBP has not decided your protest, you can amend it as long as you are within the 180 days after liquidation of the protest, or the entries involved on the protest. Next slide, please. And back to documents a little bit. While CBP understands you might not have certain documents ready to go when you absolutely need to file your protest, having them uploaded, as soon as you submit that protest or very shortly thereafter is key. You would not want CBP to start reviewing your protest or decide your protest if you're still waiting on a document from, say, a foreign producer or someone else. These documents can be uploaded into the protest module under Provide Supplemental Information. You would not want to amend your protest to upload additional documents. Next slide, please. And lastly, we come to additional arguments, which is, after a valid protest has been submitted, this is kind of where you would add any additional or alternative claims or grounds to a protest. In certain situations, this will be used to most likely, perfect the protest you have submitted. And an example might be if you submitted a protest for, say, a pending product exclusion, where the Department of Commerce or the U.S. Trade Representative has not yet decided your protest, or decided your exclusion application, but you're running up against the protest time frame, the 180 days after liquidation, submitting a protest to kind of hold that entry is possible. But you would need to then kind of perfect your protest once you get that determination back from either the Department of Commerce or the U.S. Trade Representative. And now I'll turn the presentation back over to Executive Director Leonard.
Okay, hey, Matt and Sherry, good detailed information there, and I do note we are getting questions in, and we'll address as many as possible at the end of the presentations. So at this point, let's talk a little bit about the AFR process, the applications for further review. We've got Elizabeth Grant. She is an attorney with our Office of Regulations and Rulings in our Entry and Drawback branch. And just to start things off, Elizabeth, what is an application for further review? How does a protestant successfully claim AFR?
Yeah, definitely. Thanks, XD Leonard. That's a great question to start off with. So if we could go to the first slide. So in general, an application for further review is review of the protest at a higher level, so meaning at the headquarters level, specifically my office, the Directorate of Regulations and Rulings. We are an office that's comprised of attorneys that in partial part work on protests. We are broken up into different branches through subject matter, and depending on the subject of the AFR, it'll be assigned to one of those branches. So not every protest will qualify for application of further review, and only the protests where the court director or the center director would be inclined to deny that protest are the ones that get forwarded up to my office for further review. So in general, it is incumbent on the protestant to actually submit the application for further review with its protest and to assert its eligibility for the further review. So this could be done through should a paper protest be filed on the protest form, but most often this happens in ACE. So when you file your protest in ACE, you will be able to select that you would like further review and then make certain declarations about your eligibility and then provide a space. There will be a space provided where the protest filer will be able to explain why they meet that eligibility criteria. So there will be a text box where the protestant filer can input that reason, or it's also completely appropriate for the filer to say, please see attachment. So in protests where there is an attached document that explains the arguments, oftentimes we see that the filer or the attorney has submitted a detailed reason within that filing and has simply put, please see attachment in the text box, which is also completely correct. So some of the things that are required for a protestant to receive further review is that there must have not been previously received an adverse decision from CBP, and that there is not a pending AFR with the same claim on the same merchandise. So I do want to make a caveat here in terms of like a best practice filing tip. So let's say there are 10 entries, only one of which is liquidated, of the same type of merchandise that would otherwise have the same, same decision from CBP, making the same arguments against CBP's decision in the protest. So if only one of them has liquidated and the 180 days is running out, it is completely fine to protest that entry, apply for further review, and then as the other 9 entries subsequently liquidate, those can be suspended pending the disposition of the AFR. I personally have handled protests like that, and both the attorney and support level will be able to see this in ACE, and it will be taken into consideration as the protest is processed and is final disposition is taken. And then the second is that the application for further review must allege that the protest meets one of the 4 reasons for eligibility. We could go to the next slide. So in this, there are 4 reasons. The first one is that the alleged protest is inconsistent with the ruling of customs or its designee. So here, instead of just making something like a claim that this protest meets application for further review eligibility per the regulatory site here would be 174.24. It would be best for the protestant to give what we would call a because statement, because it is inconsistent with CBP's prior decision in ruling HQH 123456. This is a way for the attorneys and the court to be able to look at the application for further review and ensure that the applicant has met it. Additionally, one reason is that it's alleged to involve a question of law or fact, which has not been ruled upon by CBP or its designees or by the Court of International Trade. So here, the example that I give is something that's novel, like maybe a novel product, like when the smartwatch first came out. And there might be a question as to what the tariff classification is, or there might be a question as to which valuation method would apply. But again, instead of just alleging the regulatory site, it would be best to say, and this is the novel product, and this is the specific issue that has never been ruled upon before. It's that last little bit that enables us to be able to say that this protest has qualified for AFR. Unfortunately, we will see and are unable to grant AFR for protests that have not been able to go beyond a mere recitation of the regulation. So by providing that extra step, it facilitates your application for further review and enables and ensures that it will receive the review at headquarters. So the third one, so another one would be if CBP had refused to rule upon the issue before it in the form of an internal advice request. And again, so there it would be, and this is the issue, whether this product meets classification under, let's say, Chapter 9505, CBP refused to issue an internal advice request. Therefore, I am applying for further review on this protest. Next slide, please. So I wanted to take a moment and discuss a little bit about how the processing happens now that we have transitioned to the ACE environment. This isn't something that is obvious to most protest filers, and it is something that differs a little bit differs from the paper protest filing. So in general, the center determines whether AFR is met, and if so, routes the protest through ACE for my office regulations and rulings assignment. So the way that this happens is they will change the protest status. My office receives a daily report on status changes of protests that are available to assignment. So it isn't something that the protestant would need to make sure moves along in the process. It's something that happens through the system and that R&R will be able to see. So once R&R gets the list of protests, we will assign the protest a headquarters number and an attorney to handle its disposition. So based off of the subjects that are listed, whether it is classification, liquidation, other valuation, something like that, it will be routed to the respective branches. The branch chiefs will look over the protest to make sure that it does belong in that branch, and then will assign it to an attorney to process that case. So once the attorney receives it, the attorney will claim the protest in ACE and will add the case number. So that way it ensures that there is continuity and that all of it's recorded in the system. Additionally, there are paralegal specialists in our office that will simultaneously send the protest filer a notice of the attorney assignment and the HQ case number. I know that during the pandemic, we have been sending these through emails. So if the protest filer sees that, we haven't received a case number, we haven't had an attorney assigned to it, it would be at that point that it would be a good idea to contact our office and inquire about whether the protest has been given a case. But in general, we will reach out to the protestant, and it isn't something that the filer would need to worry about. So after the attorney works its case, we will also check to make sure that AFR elements are met. So sometimes as we look through the case, we realize there's actually not an issue that's, new claims, new legal determinations, like new product characteristics, and we would have the ability to deny AFR and send that protest back to the center for its disposition. If we do go through the AFR and we work the case, again, we will have the letter to the applicant. We will PDF, send that through email, and we also upload a copy of the signed decision to ACE. So it will be on the record in ACE, and at that point, we will, through the process in ACE, send the protest back to the center for their disposition. And then again, as a reminder, 60 days from the date of our decision, our office will publish the decision on the Customs Ruling Online Search System, which we call CROSS, and I have included the website on its slide for your reference. Next slide, please. So should someone apply for further review and CBP denies further review, there is a statutory provision where the filer can request that CBP set aside the denial of further review. So one thing I did want to point out here is that this process is only set forth in the statute. So unlike the protest statutory provisions, 1514, that have corresponding regulatory provisions that implement those statutory requirements, the 1515C set aside denial of further review, and then 1515D request to void denial of protest, which will be discussed later. Both of those do not have implementing regulations. So we are working with the statute. So this is, sometimes I'll get calls to my desk going, well, I can't find the regulations for, a request to set aside denial of further review, which point I say, oh, it's only in the statute. So I figured I could give that as a practice tip here. So the argument that a party would make in the request to set aside denial of further review is that AFR was erroneously or improperly denied or was denied without authority for such action. Based on this legal standard, CBP, if appropriate, may set aside the denial of AFR and void the denial of the protest. So here we have some statutory filing requirements. The party must file its request to set aside the denial of AFR within 60 days of the date of the notice of the AFR's denial. So here, note that it is 60 days. I know that most people are used to working with the 180-day deadlines, but this is a much shorter deadline. Additionally, the request is filed with the statutory languages, the Commissioner of U.S. Customs and Border Protection. In practice, however, the requests are sent to the Office of Trade, my directorate, Regulations and Rulings. So even though we are in the pandemic with COVID, it is completely fine to continue to mail these requests, hard copy, to our office at 90 K Street Northeast. We do have someone that regularly checks the mail and scans in paper submissions and routes them to the appropriate branch chief. However, it is also completely appropriate to PDF the request and send it to the branch chief or to the office in general. Both ways will ensure that your request is timely received and processed. So when CBP reviews the request, our office will review and make its decision based solely on the information before the center at the time the AFR was denied. So here, we're not taking a look at new documentation. We're not taking a look at new arguments in support of that protest. So if, for example, the AFR were denied because the filer failed to allege its eligibility under one of the 4 reasons for AFR, it would not be appropriate to say, oh, and here are all these extra documents that show why our product is novel and that this is an issue that had not been previously considered. If those documents were not available to the port and the port did not think that the protestant had made a sufficient argument that it was a novel claim, that it was a novel product, or something like you didn't show that, you know, internal advice had been requested and you said that it had, the attorneys in our office would only be able to look at what had happened and submitted at that initial level. I wanted to give this as a practice tip because we routinely see filings in the request to set aside denial that contain many submissions, many extra arguments and documents that had not been initially filed, but that we cannot consider at this 1515C stage. And then additionally, CBP must decide the request in 60 days or the request is considered denied. So as a practice, our office obviously is cognizant and makes every effort to decide the request within 60 days. On the, you know, completely rare off chance that we are unable to make that 60-day deadline, the statute requires that that request is considered denied. And then additionally, if the request is considered denied, then the party can commence action in the Court of International Trade should it deem it appropriate. And so that is my presentation regarding AFRs and XD. Leonard, I'm going to send it back to you.
Great, thanks so much, Elizabeth. Good information there, a lot of good information. All right, let's kind of transition now to more operational concerns. We're fortunate to have one of our center directors, Mr. Mel Moreland, and one of his assistant center directors, Mr. Paul Sumbi, from the Consumer Products and Mass Merchandising Center of Excellence. So they have a number of topics they're going to cover. So Mel, to start you off, what should a protestant know so they will be best situated when submitting a protest to CBP? More specifically, what best practices should they follow to ensure that, 1, the substance of the protest can actually be assessed, and 2, is CBP in a position to process and approve protest in a timely fashion?
Thank you, Leonard, for the opportunity. First of all, for the opportunity to participate in today's webinar. I just want to circle back to something XD Leonard had brought up in the very beginning, was the vast increase in the number of protests received by not only our center, but all of the centers in general. The number of a 6-fold increase is actually true. All the centers are seeing, you know, upwards of a 250, 300% increase in protests. Other centers are seeing even higher. 700, 800, and in one case, 1,300%. Obviously, that's created a huge challenge for us. I know we have some specific questions, and before I turn it over to Assistant Director Paul Soomby, just want to point out that the centers have taken a streamlined approach to processing protests. We are handling, the protests are handled by teams within a center, and, it's really important the information submitted to the protest, how it's submitted, what is submitted is, I can't stress the importance of that enough. And Paul's going to get into some of that, or Assistant Center Director Soomby here in a minute. But I do want to stress that the centers handle processes uniformly. No center administratively handles protests any different than another center. We're all on board. We're all trying to help each other out. As you can imagine, it has just been a tremendous jolt to the system, and we are really working hard to handle protests as fast as we can. So with that, I'm going to ask Assistant Center Director Paul Soomby to take over and kind of go over some of the best practices that people can take in filing protests.
And I want to say thank you, Center Director Moreland, and also Executive Director Leonard. We appreciate this opportunity to speak to the trade. We are definitely in partnership trying to work together to expedite the treatment of not only protests, but all other legitimate trade that is entering the United States. As Mr. Moreland has already gone over, we have seen an extremely high increase in the administrative processing of protests. And most notably, it's been related to exclusions granted to trade remedies by the U.S. Trade Representative. There are still some best practices to be gained from processing and reviewing these protests, and I'll try to go over a few of these as we continue with this presentation. But just as Center Director Moreland has indicated, the centers universally are taking a team approach to handling protests. That is to say that if you are an importer of record, when you're submitting your protest, it's going to be going to one team. That team will handle the entirety of your post-summary corrections, your import compliance requests, protests, you name it. That team is handling your account. And so it's extremely important that communication, and I'll get into that a little bit, that communication is open and it's a two-way form of communication. So the centers handle things in a very uniform fashion. And the anticipation is that brokers, importers are going to speak specifically to that team that's handling the accounts. And one of the things that Director Moreland brought up is the kinds of information that we're going to need to process protests. And protests will typically undergo a two-step process: review on the merits, and then processing, when we see approval of the protest, processing it for an anticipated refund that the importer is expecting. With the quality of information, it's very important that an importer or a protest filer streamlines their protest filing to be specific to the item being protested. We have seen many instances where a protest filer or an importer of record is filing an entire catalog of their merchandise, and yet the entries associated with the protest only have one or two model numbers of that catalog. So the quantity of information is not important, it's the quality of it. How specifically are you addressing the issue that's under protest? One of the next pieces of information about not only related to the quality of information is how you are grouping protests or entries with protests. And what has contributed to the large number of protests that we're seeing over this last year is the fact that a lot of protest filers are filing one entry per protest. And yet they are providing the entirety of their information, be it information related to the specific item that's under protest, their information providing the Federal Register notice that substantiates a request for an exclusion to a trade remedy, And all of that they're providing on every single entry. And it seems very inefficient to do one entry per protest when a matter, for example, one specific style number is on 10 separate entries. Why would you file 10 separate protests addressing the same issue where you're providing the same information in 10 separate protests? It's inefficient for the protest filers to submit it that way, and because the centers address every protest on the merits individually, the process has to start anew on every new protest that is being reviewed. And so that is what becomes time-consuming. What is probably a best practice that we would like to put forth is that you group entries that have similar exclusions. If an importer or a protest filer has identified one or two model numbers that are subject to an exclusion to a trade remedy, and they can identify that over two or more entries, it makes sense to group those like exclusions together on one protest. In this fashion, the team that's handling the protest will be able to streamline a review of the merit of the protest and apply it en masse across all the entries that are associated with that protest. So instead of having to redo the process with every individual protest, we can address the merit first and then apply our decision accordingly to all affected entries. That would drive down the number of protests that have been filed, and it would expedite a more clean review of each individual claim that is being made. So, the next question is, well, okay, you are going to take a streamlined approach by doing a logical grouping of entries that are of the same issue. In other words, similar model numbers, same exclusion of trade remedy, and you will group them in one protest where you can provide a very specific argument for a very specific product. So then the next question, what should that information entail? Well, as you know, the exclusions to trade remedies are published in the Federal Register notice. And so information that you can provide that will assist customs are the 10-digit harmonized tariff schedule number, the tariff number from chapters 1 through 97 that are covering the exclusion, the chapter 99 8-digit exclusion number that you believe applies, and then again, that very specific product information, because as many protest filers know, the exclusions to trade remedies can be very, very general, and they can be very, very specific, which will incorporate not only sizes, weights, additional attributes of the product that have to all be consistent for it to qualify for the exclusion. So it's not just the 10-digit HTS that qualifies for the exclusion, it's the specific, the specificity that is provided in the Federal Register notice that will grant you that exclusion. And so by providing that very specific information, not only actual product information that shows why it meets the exclusion, but also identifying the exclusion, the Federal Register notice, and the exclusion that apply is going to be critical to the information that you provide. And so when you provide that information, you can go to the next slide. CBP is going to be in a process, one of two things is going to happen. So as I said earlier, this is a two-step process. First process is examining the merits of the protest. And I've kind of gone over some of the information that you should provide is very specific and not general and not abundant, just because quantity might be something that the protest filer is looking at. We want something very specific. But once a protest is vetted, if it is determined that it should be approved, then we move on to the second phase of protest processing. And that is what kinds of information should be provided. And here, this is, I'm going to, as you can see on the slide, it's not a one process fits all setup. But the one thing I would like to say is when a importer wants to make a correction to an entry prior to liquidation, they file a post-summary correction. And when they file that post-summary correction, they are essentially providing a new entry summary to customs. They're saying, customs, A change needs to happen prior to liquidation to this entry, and we're providing you with an entirely new entry summary document. So in the protest world, Customs would prefer to have something similar. And generally, there's two types of processes that will take place with an approval, with one variation. The first process is that the protestant is asking for an entire line to be excluded from trade remedies. Every product that was identified on that entry summary line should be excluded from the trade remedies. That's one of the first likely requests. Another possible request is that a protest filer is asking that every product on a specific line should undergo a classification change, and upon making the classification change, an exclusion to trade remedies should be granted. The variation is that oftentimes a protest filer will realize that maybe not an entire line, but a portion of the line is subject to exclusion to trade remedies, and then they will be requesting a line breakout for that portion. And whether you provide a revised entry summary, which is, we would say, is the gold standard, versus a spreadsheet will be dependent on what is being requested. We would generally say that when there are line breakouts, a revised entry summary, much like the post-summary correction, should be provided. When there are a complete line change, be it through a classification change as well as an exclusion to trade remedy, then sometimes a spreadsheet can be useful. Again, communicating with the team that's handling that importer of record will be critical to determining which method a protest filer should follow. But as I said earlier, the revised 7501, much like a post-summary correction, would be the gold standard, because that's what you provide us, that's what we're used to seeing in post-summary corrections. Seeing that on protest is also helpful. The key here is that the protest filer would like to receive a specific refund, and they want to ensure that Customs is reviewing it and agrees with their process of determining what the refund should be. That revised 7501 or a spreadsheet that mirrors their revised 7501 is going to be critical to making sure that Customs agrees with that assessment and processes it in a timely fashion, in an expeditious fashion, and in line with what the importer of record is requesting. And so communication, that next point is going to be key. Protest filers should be available for communication from Customs. It's a frequent occurrence that Customs will like to reach out to protest filers. And so in this case, we need information that is up to date, like who we can contact. We need a subject matter expert on the protest that's being filed, and they need to be responsive. So we anticipate that when you're filing a protest, that we will have some communication with the importer of record or with the protest filer, such that we can make an informed decision on the protest. And again, this is not a one-size-fits-all process. It's important that protest filers reach out to the centers and to the teams that are handling these accounts. If you're not sure how to contact a team, you can go to the cbp.gov website and go to the trade portion of that website. Every single team from every single center is identified by the new alpha team codes that were identified in the CSMS message back in June of this year. All those teams are identified, and a contact supervisor is also identified. You may email them, and communication can take place. Also, frequently, teams would like to have conference calls with the protest filers to have clarity on maybe a multitude of exclusions that are being requested. So the protest filer should be available for that review as well. So as long as that communication is taking place, as long as the protest filers are working closely with Customs, we believe that this will help streamline the administrative protests that have been filed recently. Next slide. This next portion has to do with requesting void of a denial. So as I have mentioned earlier, when a decision is going to be made on a protest, it will either be an approval, a denial in full, or denial in part. When a protest filer sees a denial in full or denial in part, they have a statutory right to request a void of the denial. The protest filer has 90 days from the date of the original denial to file that request for a void denial. A best practice would be that if you have filed an electronic protest, that you can request this void denial electronically in the protest module. If you filed a paper protest, clearly you would have to send a written request for a void denial to the port director in the port where you filed the paper protest. In both cases, the key to what the statute says is that the protest filer has to show how customs made an error contrary to proper instruction. And that's, as you can see there, is through CBP rulings that disagree with the decision that was made, or through court cases that disagree with the decision was made. There should be a clear explanation as to why a protest filer believes that the denial or denial in part was done contrary to proper instruction. Now, this is not a second opportunity for a protest filer to submit new and abundant information about a protest that they submitted, much like as was presented with the applications for further review reconsiderations. This is not the opportunity to say, I get a second opportunity to protest a denial by customs. You have to show that based on the information that was presented, customs made a decision contrary to proper instruction. So it is not an opportunity to submit new and compelling new information about why customs should have approved rather than deny the protest. And the most important thing to consider with requesting a void denial is that it does not toll the time required to file before the Court of International Trade. So when a protest is denied, a protest filer or an importer of record has 180 days from that denial date to file before the Court of International Trade. Requesting a void denial does not stay that time. The time still ticks as the void denial is being considered. And if at the expiration of the 180 days, the reconsideration is considered, or the void denial is considered moot, because the venue would have been the Court of International Trade. So that is our presentation, and I'd like to turn it back over to XD Leonard.
And thank you also, Mel. Really clear information as to how you can have better success at filing a protest that would ultimately be approved. As Mel stated, centers handle protests uniformly, and they are aggressively working these great numbers of protests that we have. So just please understand that. Okay, let's move over now to talk a little bit about accelerated disposition and the Court of International Trade as well. So we've got Assistant Chief Counsel Paula Smith with us. She is with the International Litigation Department of Chief Counsel. So Paula, to start it off, explain to us what it means to seek accelerated disposition of a protest, and then also please walk us through the basic requirements for challenging a protest denial in the Court of International Trade.
Certainly. Thank you, XD Leonard. Good afternoon, everyone. So starting with requests for accelerated disposition and what they mean and what the consequence is for filing one. I guess first I take just a half a step back and indicate that under the protest statute, 19 U.S.C. 1515, it states that CBP shall approve or deny a protest within 2 years of the filing of the protest. But the courts have held that period is directory, not mandatory. So there's no consequence that attaches if CBP doesn't decide a protest within that particular period of time. But the protest statute 1515B includes a provision whereby a protestant can seek accelerated disposition of a protest. So what does that mean? With a properly filed request for accelerated disposition, the CBP has 30 days from the mailing of the notice of the request to either approve or deny the protest. And if it doesn't do so within that 30-day period, the protest is considered to be denied by operation of law. So first, what does it mean to properly file a request for accelerated disposition? In terms of when, it can be filed on the same day as the protest itself is filed, or it can be filed anytime after the protest is filed up until the disposition of the protest. In terms of how to file a protest, and this part is important, the statute pretty clearly states that a request for accelerated disposition should be filed by registered or certified mail. The starting date for that 30-day period for the deemed denial starts with the mailing of the notice of the mailing of the request for accelerated disposition. So the mailing date is very important. It may seem a little antiquated in an electronic age to have to mail by registered or certified mail a request for accelerated disposition, but until the statute is amended to allow that request to be filed in ACE, the statute, again, is pretty clear that it needs to be sent by registered or certified mail. So if you filed a protest electronically in ACE, you will need to separately file by registered or certified mail that request for accelerated disposition, and it's a good idea then to upload that request along with the mailing documents into the ACE protest record, so that then becomes part of the protest record, and the mailing dates are then clear to everyone. So again, what's the consequence of filing that request for accelerated disposition? If CBP doesn't approve or deny that protest within 30 days following the date of mailing, the protest is deemed denied on the 30th day following the mailing of the request. It's important to note that filing a request for accelerated disposition doesn't necessarily require CBP to decide the protest in 30 days. And again, if CBP doesn't decide it, it's going to be denied by operation of law. And then the protestant's only recourse to challenge that denial will be to file an action in this Court of International Trade. So filing a request for accelerated disposition can be a quick way to get a protest before the court. But if a protestant isn't prepared to file an action in court, if the protest becomes deemed denied, it's probably best to allow CBP the time it needs to consider and decide a protest. So if we can go to the next slide, we'll go to filing a summons in the CIT. So, so you have a protest that's been denied, and you want to challenge that denial in court. You can file a summons in the Court of International Trade. It has jurisdiction to hear a challenge to the denial of a protest. It's a court in Lower Manhattan, for those of you who aren't aware of it, in New York City, but it has national jurisdiction, so it can hear a case no matter where the protest denial in the country arises. And the summons is filed with the court that lists the protests and entries that are in dispute. And the time period for filing a summons with the court is 180 days after either of two dates. The first is if CBP has denied your protest, actually denied it, it's 180 days after the date of mailing of the notice of denial. So for a protest that's filed electronically in ACE, that's 180 days after the notification of the denial is sent by email in ACE. And for a protest that's filed in paper copy, in hard copy, it's 180 days from the date CBP mails that hard copy denial to the protestant, which under the CBP regs is generally considered to be the decision date indicated on the Form 19 itself. If what you're dealing with is a denial by operation of law following a request for accelerated disposition, then the summons needs to be filed within 180 days of the date of denial, of the date of deemed denial, the date of denial by operation of law. Once a summons is filed, the protestant, or then called the plaintiff, has a few options. They can immediately file a complaint and get their case going, get their litigation moving right away. They can request that the government consider to stipulate or settle the case, or that summons can stay on what's called a court case management calendar for a period of up to 2 years while the plaintiff decides how it wants to proceed with that matter. So the plaintiff there has a few options on how it wants to proceed. after that summons is filed. On to the next slide. The other requirements, one main requirement that I wanted to mention for filing an action in the court is that all liquidated duties, charges, or exactions have to be paid prior to the commencement of the action. So if you're contemplating filing a summons in the CIT, be sure that all billed amounts, all duties, charges, and exactions, meaning all interest, all rollover interest, every dime, has been paid prior to the filing of the summons, or the court will lack jurisdiction to hear the case over that entry. So just something to keep in mind that can trip up some plaintiffs on occasion. The other thing I wanted to note in terms of what happens when a summons is filed with the court, under the rules of the Court of International Trade, when a summons is filed, again, the summons will lay out the protests and entries that are in dispute, and the court rules require CBP to then file with the court a copy of the protests and entries that are listed on the summons. And for years and years, CBP would file those protests and entries in hard copy paper form, and they would then sit at the court for use by the court and the parties in that litigation. But a couple of years ago, a little over two and a half years ago, pursuant to a rule change at the CIT, CBP has been filing those protest and entry documents in PDF form electronically with the court. So it's really updated and modernized its process and procedures in that respect. And we have developed a module in ACE which extracts the protest data, the relevant protest data and entry data from ACE, converts it to PDF form, and also extracts the other PDF documents in the protest and entry records that fall within the scope of the rule, extracts them out of ACE so that CBP can then compile and assemble them for filing with the court. They're filed under seal, they're filed confidentially, but then they're on the court's docket for use by the court or the parties in conjunction with that litigation. So we've been doing that for the past 2.5 years, and it's really been going quite well. The rules also require that CBP file with the court any samples that might have that CBP is in possession of that were either submitted to the agency by the protestant in conjunction with that protest, or that's listed on the summons, or that CBP may have taken from an entry that's listed on the summons. So again, if we're in possession of a sample that a protestant submitted to us for a protest that's listed on the summons, or we've sampled a merchandise from an entry listed on the summons, we will package that up and send it to the CIT, or at least one exemplar of the sample, send it to the CIT, and it will then reside with the CIT for use by the court and the parties during the litigation. My understanding is that the judges actually like those samples quite a bit. Samples are fun. Okay, next slide. Standard of review. This, I think, is important to note about how protest cases are heard in the Court of International Trade, in that the review is de novo, what's called de novo, which means anew, and the court in reviewing the matter is not limited to the record made before CBP. It's not limited to the evidence that was presented to the agency when the agency reviewed the protest. It's reviewed on the basis of the record that's made before the court. So it allows the parties, the protestant, again, then the plaintiff, as well as the government, to come forward or present or develop additional evidence in support of the claim. So it is important to note that if you have a protest that's been denied for lack of evidence, in conjunction with a CIT case, one can come forward with additional evidence to substantiate the claim. Although I would note, it is usually more cost-effective and simply more efficient to provide the evidence up front to CBP in conjunction with its review of the protest. And with that, I think we're pretty much sticking to our time, and I will turn this back to XD Leonard. Thank you all very much.
Thanks so much, Paula. Good information on accelerated disposition and CIT. Okay, we've got about 12 minutes left. We've got a lot of questions. Thank you for submitting them. We're going to try to answer as many as possible. Those that we don't, you will receive an email with an answer to the question. I'll also reiterate that this webinar is being recorded, and it will be posted hopefully by close of business tomorrow to CBP's website for future viewing, and we'll also make the slides available as well. So let me turn it over to Matt Ernst, and he'll go through as many questions as possible, and then we'll conclude the webinar at 3:30 p.m. Eastern. Matt.
As XD said, we've got a lot of questions and more coming in, so we'll try to cover as many as we can here, but also the OT, Office of Trade protest email address is listed on this final slide as well, and at the second bullet point, for any questions we don't get to or additional questions that you think of later on. So there was a question that got asked that I wrote down the answer to before I made this presentation multiple times and simply forgot to include that. And also Assistant Center Director Sumbi also mentioned the Customs Form 7501, being the gold standard of a document to submit. So this question in relation to submitting documents and submitting the corrected or the original or revised Customs Form 7501, that is not required. I mean, it is more as ACD Sumi mentioned, a gold standard that will help, limit the review time and kind of make it a more accurate review of your protest. But unless your entries were not submitted through the electronic data interface, non-EDI entries are the entries that need the original and revised 7501 submitted with them when they are protested. Some additional questions that came in about ACE allowing multiple entries on one protest. Yes, we did mention the ability to upload a file, a .txt file that has a maximum storage of 1 megabyte that can be uploaded to add additional entries to your protest. And also a maximum number of entries on the protest is another question, which that kind of is covered in the 1 megabyte kind of storage limit for that uploaded file. And as well as, the center mentioned that, there are, best practices, adding 1,000 entries to a protest might be ill-advised, as it would take, additional time to review all those entries. So, and I've seen a number of questions also about the center kind of requesting general documents or certain things from the center. That is something you should absolutely reach out to your center to discuss about what they need to review your protest. And another question was, when grouping your entries on a protest, is it necessary that they are filed in the same port as well as the same exclusion for an exclusion protest? For electronic protests, you can group entries from different ports on the same protest, but for paper protests, all the entries on that protest for a paper protest must be from the same port of entry. And see if we have any other questions I can answer quickly. And Sherry, I know you were tracking some questions. Do you have any questions that I haven't covered yet? Queued up, ready to go?
Yes, Matt, I can cover a few, and I can actually throw them out to our panelists as well. I think some of these go to the center and some go to our attorneys, but I will just start to work down the list. We do have some specific trade remedy questions. One question, is USTR still approving Section 301 exclusion requests, even though the Section 301 exclusions are due to expire on December 31st of this year? Director Amber, I don't know if you have an answer to that or if that's something we would follow up on.
Have to follow up on this. I don't know if USTR still has any open procedures for Section 301 exclusion requests. That's correct. There's many that are expiring on December 31st, 2020. Also, I believe there's a few others that are expiring in March and April of 2021. But basically, as far as I understand, if USTR does not provide any further extensions, then all of the exclusions for Section 301 will have expired by March or April of 2021, with a large number expiring on December 31st. So I recommend you, if you're importing under an exclusion, you check the expiration dates. All the information on the exclusions are both in the CSMS messages and also on USTR.gov, and we'll look into this question.
Thanks, Alex. Another question came in, and Paul, I'm thinking you can answer this. You might want to address this. Do we contact the center's entry team for the liquidation extension request?
Thank you for that question. As I may have indicated earlier in my presentation, the teams are handling accounts. So actually, your request for an extension of liquidation can be sent directly to the team. The teams can address extension of liquidation. Here in the Consumer Products and Mass Merchandising Center, we do that routinely at the team level. So if you have a good cause, as is stated in the regulation for the extension of liquidation, then the team will assess it and make a determination as to whether or not the entry should be extended. And you will receive a response to that request for an extension in writing.
Great, thank you, Paul. We have another question. I already have an ACE protest filer account. How can I, the importer, get visibility in ACE reports to what protest a broker or brokers filed on my behalf? Specifically, visibility of the date the protest was submitted to CBP and the protest number in my ACE profile. Matt or Paul, would you be able to address that question?
This sounds like an account issue. So Matt, I'm not sure if you would like to address that.
The exact answer, if I believe you should be able to, through ACE reports, kind of download the universe of your import of record number or numbers. There are protest reports you can run, but I'm not very familiar with that issue. So we'll take that back. We have the contact information, and be sure to find a solid answer for you. And there was here's the question. Question of what is the appropriate way, no, I'm sorry. I've lost the question now, but the question was, basically, where does a person go to find out, center contact information? And as our fourth bullet point on slide 30, this slide shows it gives you the link to where you can go to find out the center contact information for your center to be able to reach out to that center team for communication, back and forth for any issues that come up.
All right. Well, listen, we've got many more questions, and unfortunately, we're arriving at the conclusion of our webinar. We will promise to answer all the questions via email. We have your information, and we'll get back to you. Thanks everybody on the panel for participating. This has been very valuable. And again, we will get this up on cbp.gov, hopefully by close of business tomorrow. So again, thank you very much for your participation, and I wish everybody a wonderful day.